Our next speaker is Betsy Cavendish, Yale Law School graduate. She clerked for the celebrated Judge Gerhard Gesell, worked at the Justice Department, taught at the University of Illinois, and now is the president of Appleseed, an incubating organization established by my classmates in the Harvard Law School class of 1958. Appleseed is a model for alumni engagement in expanding public interest roles and establishing new public institutions. And if one class, part of one class, can do it, imagine all the other classes at law schools, Harvard and elsewhere, 30 years out, and what they can do. Appleseed has started 16 centers for law and justice in 16 states. Descriptions of what Appleseed has been doing are on the table, or probably here, as a stimulus for more current and coming alumni classes to emulate and exceed. And we hope that that will extend to the alumni reunions that are coming up this weekend. Betsy Cavendish oversees all this and wants to speak on the subject of change.
We have 16 in the U.S., 17 if you include our Mexico center, which I think is a really exciting place. So thank you to the audience members for sticking with this today, and to Ralph and his staff for inviting me to speak with you today, and the Harvard Record for all you do to be an independent voice of inquiry and spark important dialogue on the law and change. It is indeed an honor to share the stage with illustrious advocates and scholars. The problem I'd like to discuss today is that the implicit theory of change at law school, if there indeed is a theory of change, is that litigation drives progress. Yet the case law system, still the predominant mode of law school teaching, does not adequately prepare students to participate in the legal system as change makers, nor does reading case after case impart the skills students need to be change makers. Students are taught to place themselves above the judges. Who has the better argument, the majority or the dissent? Legal theory workshops often try to unpack what's really going on in judicial decision-making, and elite law schools can breed an arrogance that lawyers, by virtue of their exceptional brain power, verbal dexterity, and license to practice law, are the primary agents in all new legal developments. Trial advocacy and moot court, while fine activities in themselves, underscore the litigation-centric programming at law schools today. I've even been to a conference at another leading law school where the question was how Roe versus Wade should have been argued. Much of this type of study takes a retrospective view rather than asking what injustices are out there and how we can change these injustices using our skills as lawyers. My proposition is simple. Law schools could do a better job of helping students appreciate that litigation is just one way of addressing problems, conflicts, or yes, injustices. Key rulings securing rights don't typically spring forth from the brains of savvy lawyers who write compelling briefs and who serve as judges in federal courts. They are the products not only of fact-based discovery in the particular case, but they are typically embedded in a larger campaign for justice in that field. I suggest law schools can and should do a better job at preparing students for the fact development, though, for identification of problems, for melding law with organizing, communications, policy development, for advocacy going beyond litigation, for monitoring rights and ensuring them by whatever process is likely to be effective. We need to minimize the distance between rights on the books and rights in reality, and this takes institutions. Clinical programs here seem to be doing some very interesting work that's a counterpoint to this general characterization about some law schools, like helping people navigate the Affordable Care Act, for instance. But I still think we have a long way to go. We all need heroes, and it's easy to identify heroes in the law who have issued opinions with ringing declarations of rights. Glossy publications from top law firms tout their victories in litigation. But I submit that this heroic, individualistic view of the top lawyer overlooks the importance of other really important skills that are critical to making change. With a judiciary that in all too many instances is hostile to claims of rights by consumers and minorities, with the tremendous resources of corporations to litigate, with changes in civil procedure that make the aggregation of claims, jury trials, and even litigation itself a very expensive and chancy way to advance justice, we need to look for additional ways to make progress. Yes, lawyers, and especially litigators and judges, may be at the crux of critical issues for critical cases for years to come, but I submit that we need more than the heroic stories we read about in Gideon's Trumpet or the Buffalo Creek disaster or a civil action. We need a theory of change and the underlying skills to make change in today's world. I think that by focusing so much on litigation, all the other attorneys who are not litigators think that they have no role to play in making change, and that this is fundamentally mistaken. I promise I'll get to something closer to a theory of change, but first let me touch on what kind of skills and commitments we do need to make change in accord with this theory. At the most basic level, we need lawyers who have the vision or the goal of devoting some share of their professional career to seeking opportunity and justice for all. It's not a monopoly held by public interest lawyers to try to make change. All attorneys should seek justice, whether for their whole career, for some years of their career, or on matters taken on pro bono, or even through the wise advice given to paying clients. We also need the ability to genuinely listen to other people's problems and the empirical skills to discover whether anecdotes and individual problems are systemic or idiosyncratic. We need creativity. We need your creativity to figure out how to find solutions. We need your social skills, like coalition building, like how to divide tasks among groups and people. Business schools do a much better job than law schools at teaching teamwork, at having students work on group projects, skills that are essential to working in the institutions that are necessary for change making. Your social skills will come in handy if you were at a nonprofit trying to secure a pro bono team. They will help if you're at a firm trying to secure resources for a big systematic change project. They'll help if you're trying to persuade a committee to take on your justice issue as its cause or project. We also need you to ask what the law should be to ensure opportunity and justice for all, as well as what it is. This may tap into the skills you developed studying policy, economics, sociology, child development, public health, or any of a number of other issues. We need your strategic skills, not to just figure out which court is the best forum, which arguments are the most colorable, or what a good negotiating gambit might be. Rather, we need your strategic skills deployed on the all-important question of who has the power to make the change we need. How can he, she, or they be persuaded to do the right thing? What may move them varies. Is it self-interest rightly considered, that the long-term costs to not changing? Is it reputational risk, fear of lawsuits, bad press, consumer blowback? Do they want to be praised for implementing reform? Give them the credit. As one wise person said, there's no limit to what you can get done if you're willing to let someone else take the credit. Can we appeal to their desire to do justice, to do a good job, to have a success? We also need your communication skills. Don't forget your liberal arts educations. What are the resonant messages? What are the motivating messages for different audiences? Maybe pollsters can tell you this, but maybe you just need to hearken back to your English classes and unwind some of the legal speak if your targets don't speak lawyer. We need your tenacity. It's not enough to just identify a problem. We need, of course, tenacity to figure out the scale of the problem, and it may be harder to pinpoint the exact problem than you might think. We really need tenacity to figure out what can be done about a problem. Tenacity in building coalitions, in identifying who can make the change you seek. Your tenacity in figuring out if the problem is a violation of existing law or requires new law or legal change, and then making a plan to get that law enforced or to establish the new legal norm. Then it will take years, probably, to do the whole how a bill becomes law dance. Draft a law, find some sponsors, get a hearing, get it attached to a must-pass legislation, and so forth. Or you'll need tenacity and courage to paddle in the shark-infested waters of administrative law, for instance. I could go on and on about tenacity, but we also need your judgment to ask the question of as opposed to what, to push for progress, though it may often be incremental. So I think some of those themes that I'm articulating here resonate with the talk at the beginning of the afternoon on how the law school admissions testing doesn't really match up with some of the skills that you're going to need. I think especially if you intend to use your law degree to make change with some share of your time. I'd like to move to a couple of success stories that I think illustrate some of these themes about making change. On Monday, the Consumer Financial Protection Bureau's rule on transparency and remittances will become law. And that, I think it's fair to say, would not have happened without Appleseed. So how did this happen? What's this about? Well, the foreign remittance market is a $400 billion a year market worldwide. It's huge. The principal reason people migrate around the world is to go to an economy where they can make more money and send money home to their families. So it's a pretty important part of the world economy, and Texas Appleseed long ago was doing interviews, fact-based interviews with immigrants to find out what were some of their main problems. It was listening, as I said earlier. And people were complaining about the high cost of remittances and the uncertainty of getting a transaction to them. And so we worked on a pilot with some friendly companies on transparency and remittances to make sure people knew at least what the exchange rate was, because people are often sort of dissuaded or called by the song of what's the fee? Like, oh, if it's $5, they might go to that company, ignoring how much pad there is on the exchange rate. So we did a little transparency pilot. Companies hated the posting. But we learned a lot about what can work and what doesn't work and where the consumer satisfaction was on that. And then Dodd-Frank was moving along in Congress, and we got a bill on transparency and remedies and remittances included in Dodd-Frank. Now, of course, we didn't do it alone. You know, it takes Congress people to be convinced of this. But it was a bill that was moving relating to consumer protection. This was good consumer protection. So it got enacted into law, providing that remittance companies need to tell consumers right up front how much the fees are, what the exchange rate is, how much will be available upon receipt. And it holds companies in the U.S. responsible for the acts of their agents abroad. So, okay, this is great. There's transparency, and it amends a banking law that provided a right to sue and establishes a complaint process. Complaints are posted at the CFPB. Companies have to have a complaint process, and people can sue and get damages for violations. So that law that we had to work our tails off on the regulatory side, because, you know, as soon as you think you've won, like you've gotten a piece of legislation, well, it doesn't do anything if it's not implemented. And we know what a graveyard the regulatory process can be for good ideas. So, you know, we stuck with it. We pushed hard. Director Cordray was committed to this, and it was the first substantive rulemaking that was issued, and now it's going to be law on Monday. And a lot of money has gone into making this change. And if it brings down the price of remittances even by 0.5% to have the ability for consumers to compare, that'll save consumers $2 billion a year. That's a big win. We're a teeny little staff, so people can make a big change. Now, it's not a super visible change, but it will make a real difference to people who are working really hard at, you know, $10 an hour or less to save that kind of money on regular transmissions of money back to their home country. It can be a very big difference maker. And so that, I think, illustrates a little bit about some of the facts and tenacity and so forth. What's another example? Well, we try to translate the fire in the belly of hating poverty to practical ways to address it. And the earned income tax credits are a really powerful lever for alleviating poverty. And we found in New York that self-employed people were being audited at very high rates, and their claims for earned income tax credits were being disallowed. And so they weren't benefiting from a law that was designed to help the working poor. And Morrison and Foerster worked with us to turn around an agency that they they tended to work with on behalf of their very big clients to get the people at the agency to understand that their job wasn't just to detect fraud and to throw out claims, but to actually make the law on the books work for people. And the solution that Appleseed proposed, and it was largely adopted verbatim, was that people be allowed to hold and keep some little notebook where you can't insert pages and record contemporaneously their income and their expenses from babysitting or lawn care or house cleaning or something, and then be able to claim the earned income tax credit, which puts money in their pockets at tax time if their income is below a certain level. So those are two very practical examples of how, research led to figuring out who could make the change, and then it's, a dollar benefit, a good benefit to real people on really serious problems. Those are just illustrative examples of how Appleseed and the Appleseed Centers work. There are so many others. We've been involved in getting model legislation, addressing air property, HEIR property. It's the largest cause of black land loss in the South. You may never have heard of it. We tend to work on issues a lot of people have never heard of. We played a critical role in getting breakfast after the bell in poor school districts in New Mexico and in Louisiana and other places so that kids don't go to school hungry. We've secured waivers of utility deposits for people who've evacuated from hurricanes. And a fairly recent Harvard Law School graduate is staffing our one center that was unstaffed for the past few years. Bennett Magnuson, who graduated a few years ago, is now running Kansas Appleseed, and he'll be doing great work in the immigration field, foster care, and courts, and so very cross-cutting work. So the first element of this theory is basically believing that we can make a difference and that we should work for a more just society. Then we work through research, identification of solutions that are possible in the short, medium, or long term, coalition building, communication, figuring out who has the power to make the change we seek. We invoke the necessary legal strategies, harnessing the pro bono skills of attorneys, most of whom are not litigators. They're creative deal makers, researchers, policy heads, and regulatory advocates. They can help if they specialize in tax, corporations, lobbying, or even banking and bankruptcy. We help them move from a call for change to making change, and we don't just throw stink bombs and run. So at Appleseed, the tagline for many years was sowing the seeds of justice. And not to crack on my employer's name, but let's just say that our theory of change is that it's much more complicated than throwing some apple seeds over your shoulder and then finding an Ohio River valley covered in beautiful apple trees. That's a myth in the Johnny Appleseed case, but it's rather more of the long slog of farming, where you got to get up every single day, and instead of milking cows or irrigating, we get up every day to take the next steps on the path to long-term fixes to tough structural problems. So the theory is partly that it takes a team and it's over time to make change, and that we need each other's skills. Law is a critical part of making change, but not the only one. My time is short, so I'll conclude by saying that we may have moved from a world of litigation as a super central to making change to an era of Twitter. But I'd submit that neither masterful appellate briefs nor pithy 140-character messages are adequate to address the tough challenges you've heard about today from the other speakers on substantive issues. It takes a comprehensive strategy, tenacity, and institutions working in tandem, often with pro bono attorneys, for us to live up to the calling and responsibilities of our profession. And it takes the same strategic savvy and tenacity to provide opportunity and justice for all. Thank you. Oh, the website for Appleseed. Thank you. I should be a better marketer. World Wide Web, appleseednetwork.org. Thanks. Any questions? I know we're over time.
Let me just add
okay.
one thing.
Yeah, sure.
The model Betsy is presiding over can, if emulated with alumni classes in various law schools around the country, produce literally thousands of public interest law opportunities, full-time jobs, and move continually towards systemic change. When our classmates got together and planned this, we used the word systemic a lot, because you have to prevent these things from happening. That's the highest calling of the law, prevent injustice. And so any of you who know other people at law schools, get in touch with Betsy, because it's not that difficult. It's difficult to make change, but to set these groups up is well within the means of lawyers 30, 35 years out, even a small number of them. I think maybe 24 of us did this in the class of 1958, and we had some more passive support behind that. But if you see how they're operating, Nebraska, Texas, South Carolina, Massachusetts now, you'll see the beginning of a very quantitative impact in terms of the forces for justice and opportunities for law school graduates to take their conscience to work. Thank you.
Thanks.
Thanks.
Okay, thank you.
And a lot of that is right on the website that Betsy has. And what can be, Bruce Western, out of Australia, I think the only non-lawyer who's speaking today. He earned his PhD from the University of California, taught at Princeton University, and today is very nearby as professor of criminal justice policy in Harvard's Department of Sociology. He works on the connections between institutionalized racism, poverty, and mass incarceration, how they interact with each other going and coming. His many books and articles are partially revealed in the titles of 3 of his articles. 1, Incarceration and Racial Inequality in Men's Employment. 2, The Free Market Myth, the Criminal Justice System as a U.S. Labor Market Institution. And 3, Black Economic Progress in an Era of Mass Imprisonment. End quote. He's speaking here on reform, redemption, and mass incarceration. And I hope he can convey what he knows very intimately, the horrors of the Abu Ghraibs in the USA.
Good afternoon, everyone. I'm going to try and set up a video for you all, which I hope to be able to present. Oh, that's great. We're going to have audio. Yeah. It'll all be worth it, I guarantee it.
Oh, do you remember what it's called?
Yeah, it's called, that's it, that guy. Yeah, if you can, yeah, beautiful. Okay, and if we can pause it.
Do you need a certain place?
No, we could maximise it now so I can just...
You sure it doesn't like QuickTime?
On my Mac, it prefers VLC. It's a huge file too, so maybe that's the issue.
Oh, wow, yeah. Quite large.
It should take less than a few minutes. I mean, we could try QuickTime.
Sure.
I don't want to hold us up because we're running behind already.
Just gonna see.
Oh, there we go. That's good. Looks like that looks like it. pause it. I was taking my son to New York. And can we go back to the...
Wow, is this the movie? It's rather large. Okay, that's what's happening. Where would you like to return?
Yeah, if you could just sit here and I'll call on you to start it, because I may not be able to get it started. And yeah, we could just leave it here. That's fine. Oh, do you want to? No, I'm thinking we could just leave it.
I'm just going to play with it and make sure I can get it ready for you.
Okay, thank you.
Sure. Whenever you're...
Okay. Well, sorry for that delay. Let me begin. The video will be worth it if we can get it started. Over the last 40 years, we've passed through a massive experiment in criminal punishment, and long-standing principles of rehabilitation and proportionality in sentencing and individualised treatment were substantially abandoned, and they were replaced by principles of retribution and deterrence and incapacitation. And the main effect of this revolution was the fivefold growth in the scale of prisons and jails in America. And sociologists have called this system mass incarceration, and it represents a new chapter, not just in how we've responded to the problem of crime. The institutional landscape of American poverty has also been transformed. So today, I'd like to talk about research, trying to understand the scope and consequences of incarceration in America. This is a project I've been working on over the last 10 or 15 years. I'd also like to tell you about a new research project and describe what I think all this might mean for our professional and civic lives. So that's the roadmap for today. So let me begin with this idea of mass incarceration. The sociologist David Garland and lawyer, David's at the law school at NYU, the sociologist David Garland, writing about 10 years ago, coined this term mass incarceration to describe the current state of our prisons and jails. And Garland said that mass incarceration consisted of two things. First, he said there was a level of incarceration that was markedly above the historical and comparative norm for liberal democratic societies. And second, he said, incarceration was so socially concentrated that we were no longer incarcerating individuals, but we're incarcerating whole social groups. So what does this mean exactly, that we're no longer incarcerating the individual, but incarcerating whole social groups? Well, the United States is the world record holder when it comes to imprisonment. In Western European countries, the incarceration rate is around 100 per 100,000. So that's 0.1% of the population that's behind bars. There's been fairly stable for a long time in Europe. Incarceration in some countries has gone up a bit, in other countries it's gone down. So 100 per 100,000 in Europe. In the United States, the incarceration rate is over 700 per 100,000. So we're 7 times larger than Europe. Our closest competitors in the scale of our penal systems are Russia, Rwanda, Ukraine, and the Republic of Georgia. But our prison population even exceeds these competitors on a per capita basis. Now, historically, the US was not so different from the international standard. For about 5 decades, from 1925, the US imprisonment rate was also around 100 per 100,000, just like in Western Europe today. In the early 1970s, our prisons and jails began to grow, and they grew for the next 35 years. So what does this mean in terms of numbers? So we've now got about 1.5 million people in state or federal prison, and they're serving 12 months at a minimum and 28 months at the median for a felony offence. We've got another 700,000 people in county jails who are serving short sentences or awaiting trial. That's not the whole correctional population, because there are another 840,000 on parole under supervision in the community. And then there are another 4 million people who are currently on probation, having received a suspended sentence and reporting to a probation officer. So that's 7 million people altogether in this country that are under some kind of correctional supervision. This is entirely historically novel, having just emerged in the last decade or so. And as striking as these figures are, that's not the most important thing about incarceration in America. The most important thing about incarceration in America is its unequal distribution across the population. So here are the facts. Men are 10 times more likely to be in prison than women. African Americans are about 6 times as likely to go to prison as whites. And high school dropouts are about 20 times more likely to go to prison than people who have been to college. Taken together, these disparities of race, class and gender have produced extraordinary levels of incarceration among young black men with little schooling. Among African American men under age 35, if they dropped out of high school, about 35% of them are right now locked up in local jails or state or federal prison. Among college-educated white men of the same age, the incarceration rate is 0.3 of 1%. So the incarceration rate among black dropouts is 100 times higher, more than 100 times higher, than for college-educated whites. Now, of course, it's natural to say that these young African American men who failed at school are also committing a lot more crime. But 30 years ago, when crime rates were much higher than today, the incarceration rate for those young men was significantly lower. The incarceration rate is so high today for one reason only, and that's because we, as a society, have chosen the prison as our way to mark the occasion of criminal offending. And this has produced pervasive penal confinement among young black men with little schooling. This is new. This has only emerged in the last decade or so. So in all this research on the relationship between incarceration and social and economic inequality, we're also learning that incarceration has a whole variety of negative social effects on economic opportunities, on family life, and on the children of incarcerated parents. So incarceration has become highly prevalent among the young men in poor communities of colour, and for these communities, incarceration has created significant obstacles to participation in all the mainstream prosperity and opportunities of American life. So the prisons become deeply involved in the production of social and economic inequality. Because they're deeply concentrated in a small and very disadvantaged fraction of the population, the social and economic effects of incarceration have created a discrete social group. And their life experience is so distinctive and yet unknown to the mainstream of American society. Their disadvantage remains largely beyond the apprehension of public policy or public conversation. The redrawing of American social inequality by mass incarceration really amounts to a contraction of citizenship. That group of people who are full members of society, in the words of T.H. Marshall, the British sociologist, that group of people who are full members of society has shrunk as a consequence of the growth of incarceration rates. So what's more, I think, we're threatened now with a deep gap in legitimacy. The police, the courts, the prisons have significantly lost the confidence of the poor and minority communities that they regulate so intensively. Police-community relations are often adversarial, and the institutions that are charged with maintaining our safety are often viewed with enormous suspicion in those communities. So that is a thumbnail sketch of a lot of the work that I've been doing over the last 10 or 15 years. And I think the place I came to in this work was a sense that we're in a vicious circle. we had these deeper and invisible inequalities being created, and they were combining with a widening legitimacy gap between the poor and the mainstream. And this served to make social exclusion, which was produced by mass incarceration to a significant degree, quite intractable, right? The inequalities that were being created by the system were becoming extremely difficult to change. Exclusion through mass incarceration further impoverishes poor communities and breeds cynicism about the civic institutions that might bring about change. That's the problem. So the question is, how can this vicious circle of mass incarceration be broken? Much of the political significance of mass incarceration, I think, lies in its intimate connection with extreme poverty. Because of its social and economic effects, and because of the sense of injustice that it fuels, incarceration adds to the social distance between the poor and the affluent. And against this great social distance that's developed, the extension of citizenship, the expansion of citizenship, is an act of imagination. So outsiders have to be reconceived as insiders. That's essentially the political project. For this to happen, insiders, I believe, have to recognise something of themselves in the citizens to be. This is the project of humanisation. So in April 2012, a research team at Harvard began a series of interviews with 135 men and women who are leaving prison, returning to neighbourhoods in Boston. And one of my first interviews was at a minimum security prison with a man called Peter. He was an African-American man in his 40s, and he'd spent most of the last 15 years in prison. Peter had a long history of violence that was episodically associated with drinking and drug use. Throughout his life, he had dealt drugs and stolen cars and hijacked trucks and got in fights. And we've been talking to him over this past year. And in this year after his release, we've seen in great detail many of the challenges confronting those who leave prison. In the first week out, Peter applied to a community program for work clothes and a mass transit card. At first, he divided his time between a friend's place and his older sister's crowded home that also housed her fiancée, her daughter, and her granddaughter. Over months, Peter began to develop a relationship with two of his three children and their two mothers. Closer to one mother and her child than another, he seemed to have focused more attention on his 10-year-old son, though he did what he could to buy both his kids clothes and school supplies. Peter was enrolled in food stamps and Mass Health, the Massachusetts Medicaid program. Each month, he gave his $200 in food stamps to his sister, though that's now expired and he's hoping to be reinstated. Through Mass Health, he's attended mental health and substance abuse treatment. He's also had a physical and visited the dentist. Peter couldn't find work initially, but he did enrol in employment programs, doing maintenance and operating machines, and the programs paid less than minimum wage. But he thought it was important to get into a daily routine. And for 6 months in the work program, he would rise at 5 a.m, be ready to start work at 6:30 and work through to 3 p.m. Every 2 weeks, he would report to his probation officer, and at weekends, he would do community service in lieu of the $65 a month probation fee. Peter gets from place to place by mass transit and walking. He's concerned that riding in a car with friends might get him arrested. If the car's stopped by police, his probation status might come up, and that might trigger a violation if others in the car have felony convictions or if drugs or guns are discovered. He's now working regularly at a laundry, getting 40 hours a week at $8 an hour. With more interviews and phone calls, we learned a little of Peter's family history. He grew up in the Lenox Street Projects, which is a public housing complex in Boston's South End. He was a runaway. As a kid, he would leave the house for weeks at a time, living with friends, often drinking, using drugs and getting in trouble. One of his earliest memories of serious violence was when he and his uncle were involved in a midnight brawl between blacks and whites outside an Irish bar in Mattapan. In that fight, Peter saw a white man stabbed to death. That was over 30 years ago, and he was 12 years old. At 13, Peter stole a car and drove it to New York, and he stayed there for a while. Shortly after that, his father took him to live in Los Angeles. But they returned after about a year, and Peter began to live with his mother. So mass incarceration looks a lot like this. It's not just a burgeoning prison population, but it's how American poverty has come to be lived. The poor don't just live below an income threshold. Low income accompanies the tightly correlated adversity of violence, addiction, mental illness, childhood trauma, school failure, labour market discrimination, housing instability, and family complexity. And on top of all of this, we've overlaid lengthy periods of penal confinement. The future of citizenship for the poor depends a lot on how much the insiders of American society see of themselves in Peter. The totality of his life seems light years away from us. He's now struggling for sobriety, housing security, economic independence, and reconciliation with his children. Mass incarceration yields few degrees of freedom. Arrest and reincarceration are often close at hand. Can we imagine a citizenry that includes Peter as much as it includes the rest of us? That's the political question, I think. And at this point, I want to show you a video, and this is a short clip from an interview we conducted. So that was Peter. I often look at that video and think if he can be so motivated to change, so can we. He sold drugs, he's been on both sides of serious violence, and he's been locked up for most of his adult life. And for all that, he gets up at 5 a.m. and he looks for work, or he goes to programs and he meets his son after school. Street life, he says, is well behind him. But the future's hard to predict for poor men with long criminal histories. Could he once again wave a gun in someone's face, or abandon his children, or relapse to addiction? Well, sure. And a good part of Peter's humanity rests in that possibility too. And I think that's how big our compassion has to be if we're to find a way out and to retreat from mass incarceration, just as we entertain the possibility and hope that people can change. We equally recognise that they can fail, and sometimes spectacularly. Humanity cuts both ways. So let me tell one last story to suggest all of the possibility that lies before us. I was in Addis Ababa 8 months ago for a research project we have studying justice institutions in Ethiopia. And I was at a dinner with 2 Ethiopian researchers, and one of them, Mulugeta, told me about a colleague at his research institute, a German anthropologist. Well, one day the anthropologist was out in a remote area driving through a small village, and his car tragically struck a small child, killing her. The girl's parents ran outside to see what happened. The crowd quickly formed around the anthropologist. And the parents tended to the child, and the anthropologist asked that the police be called, but he was told that there weren't any police there. And the village dealt with matters like that by itself. Then the anthropologist was told he could go, but they would send for him in a few days. He returned to Addis, and later that week a message came for him that he had to return to the village. He was told that he must return alone. He went to my friend Mulugeta and he asked what he should do, and Mulugeta said, "You have to go back to the village." So he went back to the village, and when he got there he was escorted to a meeting with the elders of the village. And first he was told to pay 2,500 birr, which is about $125, to the family of the dead child. And next he was ordered by the meeting to buy a goat for the family. which he did, and the goat was immediately slaughtered. And the father of the dead child was called to the front of the meeting. And the anthropologist, and he was already standing at the front of the room, was told to hold out his hand. And so he held out his hand, and his wrist was bound to the wrist of the child's father with the entrails of the goat. The village elder then announced that the anthropologist was now a member of the dead girl's family. And that was that. He was free to go. The anthropologist returned to Addis very upset. He felt that he hadn't properly compensated the family, nor had he been punished. Mulugeta said, "You have to understand, for the rest of your life, you're now a part of that man's family. You have all of the obligations of a family member. You have to visit from time to time. If they're going through problems that you might help with, you should help them, just as a family member would help their own family." Sometimes our criminal justice system seems so large and so natural and so unchangeable, but it's only been with us in its current form for the last few decades, and real alternatives are everywhere. So are we ready for change? Are we capable of this as a society? Maybe we're too fearful or too angry or too racist. The law students in the room are about to enter their careers at a unique time, when there seems to be an appetite for a different kind of conversation about crime and punishment in America. So what can you do? Well, there's the defence bar, which I think must help clients understand all the penalties and liabilities attaching to a felony conviction. There's legal services for poor communities. There's professional advocacy. Many of you may be already committed to positions in corporate law, and from you I'd like to ask a long-term commitment to serving the public interest and the poorest communities in particular. So I want to close by giving each of us a challenge to embark on this project of change. We have to know, I think, the very darkest corners of our society. It's our civic obligation to know and understand the most severe poverty in this country and abroad. We should know and understand how crime can flourish, the costs of untreated addiction and mental illness and homelessness and food insecurity. And only then, I think, when we understand how life is lived on the margins, can we begin to see something of ourselves in the other. And I hope, amidst all the violence, ultimately find peace and justice. Thanks very much.
Thank you, Professor Western, also for that example from Africa. Our next speaker is my classmate, Arthur Miller. There's little you can say about him that can escape superlatives. He's the nation's leading scholar in the field of civil procedure and co-author with the late Charles Wright of Federal Practice and Procedure. No law student who took procedure as a course is unaware of Professor Miller's work. He has argued cases in the federal courts, spoken out against the assault on tort law, produced much scholarship in the area of privacy, civil litigation, copyright, and unfair competition. For years on ABC television and on his own cable TV program, Professor Miller showed how to explain clearly legal issues to a jargon-free citizenry. In other words, he talked plainly and accurately. After publishing last year an article in the NYU Law Review, which I think is available for you here, titled "Simplified Pleading, Meaningful Days in Court and Trials on the Merits, Reflections on the Deformation of Federal Procedure," I called him up and told him it was one of the greatest law review articles of our generation, both for his piercing arguments against serious procedural barriers to using the courts, and the mention of his own personal reactions over 50 years. Arthur may disagree with my appraisal, but as I look over his career, and when he challenged me when he taught at the University of Michigan, and I was there, and this was years and years ago, and I said to myself, he's really a very conservative person. Over the years, Arthur Miller has become like wine. He only gets better with age, and you'll see why when he comes and delivers his statement today on are the courtroom doors being blocked.
Thank you, Ralph. Sitting here is a little odd because, in a sense, I was born here professionally in this very room. I'm here in part for my 55th reunion at the Harvard Law School. But I really have only two things to my credit. One is I am Ralph's classmate. And second, I was one of those people who established Appleseed that you heard about an hour ago. And Ralph, there weren't dozens, there were only 8 of us. 8 of us. Well, he's blown my cover. I'm a proceduralist. I am among the dullest people on the planet. I've been dealing with trivia all my life, and it's all the result of the Harvard Law School, which made me that way, because I happen to have procedure from a man I consider to have been the greatest proceduralist of the 20th century. So as Ralph said, I've been kicking around with this subject for over 50 years. And throughout those years, I've always believed in the federal rules of civil procedure, particularly Rule 1, which says that the rules are designed to provide the just, the speedy, and the inexpensive resolution of civil disputes. That's the aspiration. I believed in that. And indeed, the people who wrote those rules in 1938, this is the 75th year of those rules. They believed in citizen access. They believed in deciding cases on their merits, not by tricks or traps or obfuscation. Those rules established a simplified, plainly worded system. Some of you who have been to law school, here's a quick refresher course. That system supposedly starts with a very streamlined pleading system. You come in and you say, I hurt and I want something. That is to be followed by wide-angle discovery to reveal all of the facts relevant to the dispute. The principle is simple: equal access to all relevant data. If you're going to decide a dispute, it's much better to decide it in the light rather than the dark. Summary judgment motion, a trifle, as originally conceived. And then you came to the gold standard of American civil justice, a trial. A trial, and when appropriate, a trial before a jury. It all seemed very American to me. Apple pie, baseball, motherhood, the flag. You know, trying to get it right after an adversarial contest. That was the aspiration. That was the conception. For years and years, judges administered those rules that way, and law teachers taught those rules that way. But of course, in the 75 years of the rules, we have experienced societal and technological revolutions, particularly following World War II. It's transformed the business of our courts. We've seen in the last 65 years the development of complexities in federal law never dreamed of by the draftspersons of those rules. None of you, maybe Ramsey, was there in 1938. I wasn't. But in 1938, the securities laws had just been born. Tort law was primitive, absolutely primitive. It had this thing called contributory fault, blocking recovery. The civil rights revolution was about 25 years away. Neuralgic statutes like RICO and ERISA, let alone the impenetrable Patriot Act, could not have been conceived of in 1938. Indeed, today's world of civil rights, employment discrimination, environmental, consumer litigation, product safety cases, class actions, mass actions, they didn't exist when those rules were formulated. Indeed, most of that I've just described didn't exist when I sat here in the 50s. Mine was a world of library books, fountain pens, manual typewriters, and, some of you may remember this, carbon paper. Now, the good side of what's happened since 38 is that we have developed a public interest and social action wing of our profession. Much wonderful and creative legal work, all in the public interest, has been done by lawyers pursuing the private enforcement of national policies. Indeed, sometimes we call them private attorneys general. In a way, Appleseed, although it doesn't litigate, is a product of this development of public interest lawyering. Think of some of the things that have been accomplished. Tobacco was cabined by the private bar. Asbestos was defeated and eliminated by the private bar. Defective pharmaceuticals, such as diet drugs, Vioxx, have been removed from our midst, and illicit financial and market practices of companies such as Enron have been handled by the private bar, not the regulators. Indeed, we now have a dual regulatory system. Yes, we have the SEC. Yes, we have the Antitrust Department. Yes, we have the FDA, but we also have public interest lawyers, social action lawyers, and even plain old plaintiffs' lawyers who admittedly work for money, but they achieve socially useful ends. But today, the work that these people have been trying to do since their birth is being impeded. It's being impeded by a backlash that's set against the private enforcement of public policies. Special interests vilify the plaintiff's bar. We're called fee-hawking ambulance chasers. Americans are defamed as litigious fortune hunters in some sort of litigation lottery. Bogus statistics are generated. Fears are spread that we're in the midst of a litigation explosion, rendering American business uncompetitive in a global marketplace. Politicians make merry with their attacks on the justice system, cloaking themselves in the mantle of tort reform. Urban legends are spread, sometimes fabricated. The McDonald's coffee cup case is one such example. No one reports the actual facts of that case. Now, all this is given traction by our Supreme Court, which seems to have a thumb on the scale favoring defendants, that has had significant consequences on citizen access to the courts. I pass the fact that substantive rights have been strangled, the civil rights field, the employment discrimination field, the securities field, the antitrust field. Indeed, Citizens United, in the name of the First Amendment, is a corporate case. What I focus on, being a narrow-frame proceduralist, is what's happened to our civil justice system. Simply put, that litigation gold standard I described a few minutes ago, trial by jury, doesn't exist any longer. The number of cases that actually go to trial are under 1% of what's on the federal dockets. Indeed, one of the liveliest subjects at bar conventions is the vanishing trial. I'm sick of those panels. Now, there are many reasons that are advanced. Here's my reason, and I guess this is why I'm here today. In my view, the trial has vanished because our federal courts are terminating cases earlier and earlier and earlier. It has been a gradual, almost invisible process. I date the process 25 years ago. It begins when the Supreme Court decides 3 summary judgment cases. Oh my, how boring can I possibly get? The court invigorated summary judgment, said it was a procedure that should be used. And guess what? More defendants made the summary judgment motion. More courts granted the summary judgment motion. That trilogy of cases has set off a sea change, blocking trial at the summary judgment point. It's now constantly, universally invoked by defendants. If you're a defendant lawyer, of course you're going to make the summary judgment motion. You might win it. Indeed, it might be legal malpractice if you don't make the motion. Who knows? The net effect, of course, has been an increased rate of motions, increased rate of dismissals based on the motion, sometimes with judges doing what they are not supposed to do on a summary judgment motion, namely make fact determinations, snatching it away from the jury. The hell with the Seventh Amendment. It's not the First Amendment, it's only the Seventh Amendment. Even when the summary judgment motion loses, the defense attorneys have mounted costs, delayed the forward motion of the case. They're billing by the hour. In many cases, the plaintiff's lawyers are on a contingent fee. It's like a free fire zone. Make the motion, take time out while the judge decides it. Classic attrition and delay. Move 7 years, 93, Daubert. Daubert, hey, we're in the judicial gatekeeping business, right? Who the hell said we needed gatekeepers? Gatekeepers about what? Expert testimony? Okay, time out. Let's have a hearing on the qualifications of the expert. Let's delay. Let's mount costs. Let's make people pay for experts. Does the defense bar or corporate America really care? No, the lawyers are billing by the hour, and it's a taxable deduction. Plaintiffs' lawyers, they're on contingent fee. The expert is out of their pocket many, many times. Next, Next, class actions. Now, I'm one of those nuts who happens to believe in the class action. I believe it is about the only way of achieving aggregate justice for numerous people who have been injured in relatively small amounts of money or ways so that individual litigation is economically unviable. In other words, there is no justice for them absent the class. Well, you all know, at least the lawyers in the room know, of Walmart versus Dukes. Now the Supreme Court says to class action plaintiffs, you got to basically prove your case at the certification point. If you can't, go away. I thought trial was for proving your case, not certification motions, another screening device. And by the way, corporate America, if you don't even want to run the risk of the class action, put an arbitration clause into your consumer contracts. Tell everybody who buys your product or rents your cars or takes your credit cards or opens a brokerage account, thou shalt not litigate. The hell with the right to a day in court. The hell with the right to jury trial. It's contractual, saith the court. The Arbitration Act, which was never designed to deal with consumer and employment cases, but only to deal with intercorporate disputes, now will dominate civil justice. And last year, Italian Colors, horrendous case, Supreme Court didn't even care that it was demonstrated that unless you could arbitrate on a class basis, the individual arbitration's economically unviable and would never be brought. Court didn't care. Next one, my personal favorite, the Supreme Court's pleading decisions, right? Easy access? Hell no. Let's make people plead a plausible case. Make them plead facts, exactly what the rule makers said we don't want. We want a short and plain statement. We don't want facts. The two Supreme Court decisions, 07 and 09, say plead facts, plead a plausible case. How does a judge know what a plausible case is? Advice from the Supreme Court? Use your judicial experience and your common sense and consider a legitimate explanation for the conduct. What? What? That's not what a pleading was designed to do. Judicial experience and common sense? In other words, your worships in black robes? Look in your gut. What does your gut tell you? Huh? Isn't that what we have jurors for and trials for? No, look in your gut, judges. It's the ultimate appeal to subjectivity. So if you went to Andover, you have one view of the world. If you went to PS 225, you might have a different view of the world. I think more of our federal judges went to Andover than went to PS 225. We have now eliminated simplified pleading. We have made the motion to dismiss based on the complaint into the substitute for trial. We've morphed it so that resolutions on the merits are being made on a single piece of paper, the complaint. Because the court has said, unless you can plead plausibly, you don't even get into discovery. Trial, not for you. Juries, forget about it. We're going to deal with you on the pleading. Now, I could go on and on with illustrations like that. For 25 years now, the Supreme Court has been creating stop signs. They're stop signs. They're procedural stop signs. Before you go to trial, you've got to plead correctly. You've got to get your expert. You've got to survive the class action motion. Then we'll deal with you on summary judgment, assuming you get that far. It's a remarkable transformation of civil justice in this country. The judiciary really has shifted the procedural system dramatically against plaintiffs. That means consumers, that means employees, that means minorities of every size, shape, and form. That means the little people and the middle class. Now, I, for one, believe that our system's unbalanced at this point. I, for one, believe that a system devoted to gatekeeping, early termination, procedural stop signs is not the American system. It's certainly not the system I grew up with. And it's time for us, through all of the opportunities lawyers have, through public interest, social action, Apple seeds, the halls of Congress, et cetera, to turn this around. Our aspirations should be those of the Founding Fathers. They embedded them in the Constitution. They committed us to the rule of law. They engraved equal justice under law on the front of the United States Supreme Court. They should not be to obstruct citizen access to our justice system by creating a procedural wall of stop signs, because, folks, that's what we have now, and we've got to turn it around. Thank you.
Does anybody have a question? That was a masterful summary of a dreary proceduralist who isn't so dreary. And I hope that a lot of students around the country see that as well. Yes, do you want to, you have to, yeah. This is.
It seems like the events that you described, Arthur, happen to come at the same time of the rise of interest in law and economics. Once the two had merged, you begin applying principles of economics, Pareto optimality, all of these principles to the legal system. Do you see a connection between the law and economics professors and advocates in Chicago School, et cetera, and this trend?
I hate to be puckish in response because it's a very legitimate point and question. But my instinct about the leaders of the economics and law movement is they can't count past 18. They stop at the 18th century. When you deal with Posner, who was a giant, when you deal with Posner and Epstein and some of the people on what is now my own faculty or my former faculty here at Harvard, it seems to me that they have sterilized and dehumanized many aspects of our litigation system by breathing too much economics in. But that's a personal view. Maybe I should have taken more economics in college, but I didn't.
I wanted to ask, Professor, if you think one of the reasons for using these procedural technicalities as gatekeepers is the mushrooming caseload, and so the federal court system becomes more assembly line justice as opposed to individualized justice. And you can find that also in the custom now of unpublished opinions that typically are written by their law clerks and are ordinarily quite unpersuasive and disappointing to a litigant who expected a more cogent explanation. The second observation I have is that I think in parallel with the misapplication of the federal rules of civil procedure, the U.S. Supreme Court has created constitutional barriers, especially the doctrine of standing or mootness. Even you have prudential concerns. The most recent case, for example, to kick out an effort to examine the constitutionality of the FISA Act, which now is known through Ed Snowden as PRISM, that basically sanctions general search warrants. But that's just another example saying, well, because the state secrets doctrine prevents you from knowing whether you've been intercepted, now you just have to wait until there's a leak through WikiLeaks or something so you have standing. So it isn't just the federal rules, it's the substantive law of the Constitution that also is acting to block access to the courts.
As to your first point, is the caseload a factor? Let's face it, other than public interest lawyers, the worst paid professionals in the law are judges. They work hard, they're underpaid, their caseload in various parts of the country, very heavy. Not everywhere, but some places. You hear them talk that way. Is that a justification or an excuse? It's clearly an excuse. I don't think it's a justification. Because if your caseload is heavy, if you're trying to get throughput, maybe there are other ways other than early termination, more effective management tools, the use of parajudicials, more burdens on the lawyers to accelerate. That's my view. If you read the cases, it's stunning. To justify a lot of what's going on that I described, the courts, not Posner, interestingly, but the Supreme Court, in opinion after opinion, say things like, we have to cut expense, we have to cut abuse, and we have to eliminate the threat of extortion by those evil plaintiffs' lawyers. Now, you look at those statements, and a singular fact is they are not supported by any citations. They're coming from up here in terms of their own biases about litigation. Indeed, there's a lot of empiric evidence that says each of those alleged damnations is just plain wrong. It's just plain wrong. It's an easy kick me. My own view is we have a court in which several of the members are clearly business-oriented and government-oriented. John Roberts was my student. I have no illusion as to where his head and his heart are. They are just business-oriented. They believe what they're saying about American competitiveness. I also believe they are litigation phobic. They do not trust the system. They don't trust the trial judges, and they don't trust juries. I find that incredibly sad, but I believe it is true. On your second point, you're absolutely right. The Supreme Court in recent years has developed an entire network of front-end substantive dismissal bases. You mentioned preemption, exhaustion of remedies, standing, statutes of limitations, and time restrictions. It's a very clean way to get rid of cases. It's highly technical. Lawyers love that sort of stuff, and they do it. So in parallel, these front-end defenses and the procedural restraints, what I call stop signs, make it an obstacle course.
How much, Professor, do you think is working, at least with the Scalia, Roberts, Alito side, with the idea that they grew up thinking in the Earl Warren era that the judges were getting too much involved in social policy, and therefore there was just this idea, we got to keep cases out of the courts because they shouldn't be making policy. Hey, just go to the legislature, get your billionaire to lobby, and that's your remedy. And at least for that side of the court, what I would say would be Scalia, Thomas, Roberts, and Alito, that's sort of a frame that transcends the particulars of the substance.
No, I think that's right. They don't want judges in policy-making roles. I mean, the paradigm there would be Scalia and Roberts. It's a complete antithesis of the Warren Court. No doubt about it. And, life is a pendulum. Those of us who lived through the Warren Court saw the pendulum out here. Now that we're in the Roberts Court, the pendulum is out here. One hopes that the magic rule of pendulums, namely that it will retrace its arc, will happen. Not in my lifetime, maybe in some of your lifetimes.
Thank you.
All right, I'll go away.